Okay, there are still some folks signing on, but let's go ahead and kick off the program. So welcome. Thank you for joining us today for our webinar on the CCPA. I'm Lisa Sotto, and I head Hunton's Global Privacy and Cybersecurity practice. Despite everything that we're experiencing at this moment in time, the CCPA is here to stay. So we need to continue to make sure that we're at the top of our game in managing CCPA compliance. Today, we'll be focusing on how to prepare for the inevitable onslaught of class action litigation that we see coming. We'll spend also a few minutes at the beginning getting you up to speed on the third set of modified regulations that were released in March. If you have any questions during the program, you can use the Q&A feature on your screen to type in your questions. And if time permits, we will address the questions toward the end of the webinar. Note also that the webinar is being recorded and we will make the recording available for you after the program. Now, I'd like to introduce the true experts who are going to be advising us on the litigation risks of CCPA during the webinar. So my partner, Marie Mortimer, who is resident in our LA office, co-heads the firm's commercial litigation practice, and she has handled many data breach and privacy class action lawsuits, and notably, she is lead litigation counsel on the 40+ Yahoo class action lawsuits, which, as you may recall, was the largest data breach in history, impacting over 3 billion user accounts. Marie has received so many accolades. I'll just note a couple of them. She has been named a technology trailblazer, a litigation trailblazer, one of the top 100 lawyers in California, and many other accolades, too many to mention here. We're also joined by Jason Kim, who is counsel, also resident in our LA office. And like Marie, Jason's practice focuses on class action defense and complex litigation in the data breach and privacy contexts. So Jason and Marie have really extensive experience dealing with the key plaintiffs firms in this area in privacy and cybersecurity, and so they will enlighten us today. With that, let's dive into our program. Just to give you a sense of who we are in our practice at Hunton, we have about 50 privacy and cybersecurity professionals in the US, the EU, and Asia. We're really everywhere around the world, and we represent clients in every industry sector. We've listed a few here, but really across the board. We have handled about 1,700 or so data breaches and cyber incidents to date, and as I mentioned, including the largest one in history to date. And if you're very interested in this area, I would commend you both to our privacy blog, as well as the website for the Center for Information Policy Leadership, which is a privacy think tank associated with the firm headed by Boyana Bellamy, who was formerly the Chief Privacy Officer of Accenture. And no privacy practice would be complete without a Twitter handle, so there it is, and I welcome you to please join us electronically on these various venues. Okay, we're going to dive into just a quick update. I'm going to just spend 10 minutes or so updating you on the CCPA regulations, because these are new and really at the fore at the moment, and then the rest of the program is going to be devoted to the litigation risk. The CCPA, the law, mandated that the California Attorney General adopt regulations to further the purposes of the CCPA, and these were required to be in place by July 1, and really to put flesh on the bones of what we all know now was a hastily passed and fairly ill-considered law. Since October, there have been multiple iterations of the draft regs, they were first issued in October of 2019, October 11th, and this promulgation kicked off the draft, kicked off a comment period that closed on December 6th. So there was some real time there to put comments in. And in response to extensive comments that were received, the AG then proposed modified draft regulations on February 10th. And they opened up a shortened 15-day comment period that then ended on February 25th. The AG then proposed, and I really did fall off my chair when I saw these, proposed yet another set of revised, modified draft regulations on March 11th, and opened yet another 15-day, so again, a truncated period here, 15-day comment period that ended on March 27th, just last week. So now, what we're looking at is a full compilation of 3 sets of draft regulations. The most recent version had really very few and relatively minor changes to the version preceding it, which suggests that the regs may be in close to final form. So if the comments that were finished and published on March 27th result in further substantive revisions, then the public will be given another opportunity to comment. If they result only in non-substantial or grammatical revisions, the AG could adopt them at that point. So just to give you a sense of when this may in fact be coming down the pike, once the regs are adopted by the AG, the Attorney General needs to then send the adopted regulations to the California Office of Administrative Law for approval. The Office of Administrative Law has 30 working days to approve the regulations, and then will send them to the Secretary of State for filing. If the Office of Administrative Law does not approve the regulations, then they need to provide the Attorney General with a written decision detailing the reasons for disapproval. And the AG then has 120 days to rewrite them and resubmit them to the Office of Administrative Law. And really what we're thinking about the effective date and when it might be, but it really is just going to depend on when the regulations are filed with the Secretary of State. Typically, if regulations are filed with the Secretary of State by May 31st, they will go into effect on July 1. But the other possibility is that if regulations are filed between June 1 and August 31, they typically would go into effect on October 1. Now, I'll also note that the AG is permitted to request that the regs become effective on the same day they're filed with the Secretary of State. So that may happen here. And importantly, and this is why we're doing this program, even if the regulations are not effective by July 1, the Attorney General could still start bringing enforcement actions on July 1. And of course, class action lawsuits will proceed apace. So to go through some of the key concepts, beginning with the first draft of the regulations, which were the ones issued in October 2019, all of the drafts have covered similar concepts within the general same framework. The regulations address in detail the various notices to be provided to customers, which are the notice of collection, the notice of the right to opt out, the notice of financial incentives, and the privacy policy. And I realize that I'm sort of diving into the middle, but so many of us are so familiar with the CCPA at this point that I think having this higher level discussion is probably useful. The regulations also provide instructions to businesses for receiving and responding to consumer access, deletion, and opt-out of sale requests. And I will persist in calling them access requests instead of right to know. It just seems so out of step with the rest of the world that I have not been able to shift my brain to right to know. So just so you know what you hear when I say access. We've also received from the regulations detailed information about how businesses should verify consumers' identities. One of the most controversial aspects of the draft regs are the rules around non-discrimination and data valuation, and businesses have struggled mightily to figure out how to appropriately calculate the value of consumers' data, which is required under the draft regs where businesses are providing financial incentives or price or service differences. Those are the defined terms. These are, for example, loyalty programs. The regs also provide for a number of additional permitted uses for which service providers may use personal information that they get in the course of providing services. And this is a real positive, I think, added to the regs that really allow service providers to use data to enhance their own services, so critical. And it's been a real sticking point for service providers under the law, which did not allow for these sorts of uses. The regs also contain requirements regarding training and record keeping, and they have the dreaded requirement to publish metrics regarding the business's intake and response to consumer rights requests if the business annually processes the personal information of 10 million or more consumers. There was a mistake in the February version as it originally was issued, just to say 4 million. This was changed to 10 million just a few days later. So actually we can call it the fourth iteration of the regs. Okay. The modified regs generally cover the same concepts as the initial regulations, but the modified version really brings the regulations closer to the text of the law. The first version of the regs, just in so many places, really went outside of the four corners of the law. It was actually pretty surprising to me to see that. But now they've been pulled back and they really are much, much closer to the requirements in the law. And this, of course, suggests that they may be closer to final form than not. Next slide, please. Because the March changes were fairly minor, I'm just going to spend a few minutes discussing the revisions in both the February and March versions sort of together. So the modified regulations really, as I said, reined in many of the concepts that went beyond the four corners of the statute. So for example, the initial draft of the regs required a business's response to a request to know categories of personal information to be tied to each category of personal information. Each category of personal information needed to be tied to the relevant sources and purposes. This sort of linking is not required under the statute, so it really would have imposed a significant burden on businesses whose due diligence efforts at the beginning of this whole exercise were simply not designed to address this kind of information matching. The modified draft regs removed that linking requirement for the purposes and sources. And these, of course, now were pulled back to really match the text of the law in responding to requests to know. Just to give another example, in the initial draft of the regs, there was confusion as to whether businesses needed to adopt EU-style cookie notices, because one section of the regs said that businesses needed to provide notice of collection before the point of collection of personal information. And in fact, this inconsistency has now been resolved, and the modified regs clarify that notice needs to be provided at or before the point of collection of personal information. So we are not in EU cookie land. There were also a number of smaller changes, like clarifying that a business may not use a consumer's personal information for purposes that are materially different from those that are disclosed in the notice at collection. The regs added just-in-time notice requirement where you're collecting PI through a mobile device for a purpose that the consumer would not reasonably expect. Some of this is very, very much in keeping with the FTC's expectations, so not so new, really, but just now set down in law. The modified regulations also clarified that businesses need to respond to access and deletion requests within 45 calendar days. They need to act on an opt-out of sale request within 15 business days. I have no earthly idea why. Some are calendar days, some are business days, but there it is. And so we need to really pay attention to those timing variations. The modified regs also prohibit businesses from requiring consumers to pay a fee when you're verifying identity. And I know some businesses were requiring notarized affidavits. So you can still require those, but you'll have to pay the cost of those if you do. So probably not something that is of interest to many businesses anymore. So I'm gonna wrap up and turn the program over to my colleagues for what is really the gist of this webinar. But I'll just wrap up by saying that it is very frustrating that we don't by now have a clear and predictable path for CCPA compliance. There's no assurance that the rules will remain as is, although I am guessing that they are in close to final form, but we can't know that for sure. So I would say, given that we think that they're pretty close to final, businesses would be wise to pay close attention to the latest round of draft regs. And I will turn this over to Anne-Marie.
Thank you, Lisa. Well, in the absence of clarity and predictability, I think what counts is expertise. And so as a humble litigator, I'm so happy to have Lisa, who's truly first in class, with her team to provide the regulatory advice about how companies do get CCPA ready. In terms of the CCPA and the private right of action, there's a lot to unpack here. And first, I guess I should say thank you for joining us in these unprecedented times. I will say that I'm very happy that we're all here virtually and with slides. I can guarantee you that my hair today does not look like what it looked like in that bio picture, but we will do our best to muddle through. So the CCP right of action gives consumers a private right of action when their non-encrypted and non-redacted personal information becomes the subject of an unauthorized access, exfiltration, theft, or disclosure as a result of the business's violation of the duty to implement and maintain reasonable security measures. So there's a lot packed into sort of threshold showing for that private right of action. And what we're going to do for the remainder of the time today is take you through what the threshold elements are for private right of action, try to put that into context for you of how the litigation landscape shifts with the addition of the CCPA as part of the plaintiff's arsenal. We're going to talk about the limitations on the use of the private right of action, and then we're going to shift and talk about some defense or mitigation strategies. I'm going to preview, though, what the message here is that, we've all read about the spate of data breach lawsuits. New ones come every day. And by the way, already several have been filed with respect to the CCPA, although the regulations aren't even finalized yet. That hasn't stopped the plaintiffs' bar from bringing lawsuits. What's different about the CCPA, though, is in many respects, data breach lawsuits up until now have been claims of harm looking for a theory of damages. And with the addition now that there's no requirement of proof of actual harm and the important change of attaching statutory damages, as we will discuss, that has a number of important implications. One is that it helps plaintiffs clear the standing bar, which is a threshold showing, because there's no proof of actual harm required. And most importantly, this statutory damage provision is like supersizing data breach lawsuits. In many respects reminds me of the TPCA lawsuits.
So let's talk about the actual elements of the private right of action. So first, non-encrypted and non-redacted personal information, subject to an unauthorized access and exfiltration, theft, or disclosure. As a result of the business's violation of the duty to implement and maintain reasonable security procedures and practices appropriate to the nature of the information to protect the personal information. So how do we tackle these elements? Non-encrypted and non-redacted. So encryption, encryption, encryption. Now you might ask, what kind of encryption are we talking about? From a defense perspective, we would argue that personal information that's not in plain text is encrypted or otherwise redacted. Of course, in the case of a data breach, plaintiffs, surely as the sun will rise, are going to argue that any encryption measures employed by the defendant were insufficient, simply by virtue of the fact that a breach occurred. Of course, these issues have yet to be hashed on the courts. So In the meantime, this is sort of a battle that should be won before it's ever fought. Companies can start protecting themselves now by encrypting or redacting personal information using industry standards, best practices. So are we using defensible industry standard encryption protocols commensurate with the type of information we maintain? Do we maintain highly sensitive data in plain text? Plaintiff's case, it's going to be a lot harder if a company can prove it employed defensible industry standards and best practices. And I know personally, I'd rather depose a plaintiff's expert who's going to have to concede that the client employed such practices. Personal information. So at the outset, one point I want to make here is how breach notification laws in the US are triggered by a limited set of data elements as opposed to other countries. So personal information on the CCPA's limited private right of actions, it's going to include things like social security numbers, account numbers, credit card numbers, medical information, health insurance information, certain types of biometric data. Now compare that to the sweeping definition under the CCPA generally, which is going to define personal information as, quote, information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So bottom line, we don't want to take this element for granted, and we want to make sure that actionable data is actually in play. Subject to unauthorized access and exfiltration, theft, or disclosure. So one thing I want to note here is the difference in wording from the wording of California's breach notification law. Here we see unauthorized access along with exfiltration, theft, or disclosure. Breach notification law, on the other hand, calls for notification when an unauthorized person has acquired personal information. Now, may seem like a distinction without a difference in the long run, but it's curious that the legislature chose to word the provisions differently, and enterprising plaintiffs might try to exploit that distinction in the lawsuits ahead. Second thing to note on this one is the timing. Plaintiffs might try to bring claims related to breaches that occurred before January 1st. And we've seen one instance of that already. Now, having litigated this issue with respect to already existing data breach notification law here in California, I can tell you plaintiffs probably are going to face an uphill battle in terms of retroactive application of the CCPA's private right of action.
In the absence of an express legislative indication that the law was intended to be retroactive, it's usually prospective. We've litigated this and won before, so plaintiffs arguing that the CCPA should apply to past breaches will, as Jason said, face an uphill battle.
So again, this is an element when you have a data breach where it might seem indefensible, but again, even if you have an unauthorized access, has there been an actual exfiltration, theft, or disclosure? Did the hacker obtain some or all of the data in question? These are issues that we want to nail down early so we can understand class action exposure, because some putative class members' information might have been exfiltrated, others might not. And these are going to be key differences in the long run to limiting the size of the putative class and consequently class action exposure. So we don't want to take this element for granted.
So as Jason indicated, one of the real battlegrounds of the CCPA is going to be what constitutes reasonable security. And although there's no true safe harbor provision in the California statute, we have benchmarks. So let's talk about a few of those benchmarks. First is SIS-20, California's 2016 data breach report. Then Attorney General Kamala Harris stated that if a company complies with those 20 controls, that they identify a minimum level of security, and that if the company does not comply, that indicates a lack of reasonable security. Now, it's important to note how those comments were framed. They're framed in terms of SIS-20 or NIST cybersecurity framework or any of the other benchmarks being a floor, not a ceiling on reasonable security. And that's important because if you compare the CCPA with some other state statutes, for instance, the Ohio statute, privacy statute, there's a true statutory safe harbor. So in other words, if a company is able to show compliance with certain benchmarks, that they're insulated from liability. Here in California, again, it's more likely that courts and certainly the plaintiffs will argue that these benchmarks are just a floor, not a ceiling. And by the way, compliance is sometimes difficult. For those of you whose companies have done, for instance, maturity assessment reports, and they have those very colorful stoplights that I guarantee you will see should the issue ever be litigated, the average company, depending on size and scope of business, usually scores on a scale of 1 to 5, somewhere around 2 to 3. So what that means is there's almost always room for improvement. So this will be a true battleground of CCPA, and I want you all to keep in your mind this notion of reasonable security as we cycle through and talk about litigation, because one of the mitigation techniques I'm going to recommend to you at the end is to be very mindful of communications and how you describe your security posture for this reason. Here's the crux of the coming tsunami, I suspect, of CCPA litigation, and that is that there's a statutory damage provision. So it's the greater of actual damages or statutory damages for each violation. Statutory damages of not less than $100 and not greater than $750 per consumer per incident. And then, of course, there's also an injunctive or declaratory relief provision. I want to pause, though, on the statutory damage provision, and I want to give you a little context. Those numbers seem high, but you really only realize how staggeringly high they may be when you do the math. So if you consider some of the larger data breaches that have been the subject of early litigation, and there's no real established track record for data breach litigation, most of them go up to maybe the class cert point, and most are settled. But if you look at settlements for data breach classes, particularly larger settlements, on average, they range about hovering around 19 cents per consumer. So think about that a minute, 19 cents per consumer. Even what's been reported as some of the larger data breach settlements, take for instance Anthem, which at the time it settled was reported as the highest per consumer settlement was $1.50. So put into context, we're talking statutory damages $100 to $750, when the landscape we've been playing on puts a price tag on average of 19 cents and up to $1.50 on settlements. It's a sea change. And I think it'll be much like what we saw with the TPCA, which is the penalties are so staggeringly high, the plaintiffs will file a barrage of lawsuits in the hopes of an early settlement to avoid the risk even of these very large statutory penalties. There's another important implication of this, which we'll talk about in the standing context, but also one of the challenges for class action plaintiffs that we saw recently in the Facebook litigation and other litigations is not only trying to quantify and prove damages on an individual basis, given the ubiquitousness of breaches, but even more so on a class basis. So again, having a statutory damage provision has a ripple effect across this type of litigation. In terms of determining that range between $100 and $750, the type of factors that might be considered are the nature and seriousness of the misconduct, the number of violations, the persistence of the misconduct, the length over time in which the misconduct occurred, the willfulness of the defendant's misconduct, the defendant's assets, liabilities, and net worth, and of course the catch-all of any and all relevant circumstances. So again, this is where past conduct might actually come into play, and where, as we'll talk about, the sort of internal communications might come into play in terms of determining on a sliding scale how serious the conduct is.
So again, I don't know if I'm still cutting out.
No, you're here, go ahead.
So one thing that I wanted to point out too is if we take a look at each of these factors, and these, as Ann noted, are all the factors that the court's going to look at in determining statutory damages. One thing these all have in common is it all relates to the defendant. So that right there, as Ann previewed, creates the potential for a common body of evidence that can be used determine all these factors. Now, compare that with actual damages, which plaintiffs had to prove in the past, where the existence, type, amount of damages, all of that had to be established with individualized evidence unique to each class member. So we can see how the CCPA has removed a common stumbling block for plaintiffs, and that's the ability to prove damages on a class-wide basis with common evidence. Safe harbor. So consumers first have to give the company written notice of the breach and 30 days to cure. And this applies to the statutory damages provision we've been talking about. So plaintiffs cannot seek statutory damages where a cure has been effected within the safe harbor's 30-day period. Again, this applies only to statutory damages, not actual damages. But if I have to describe this safe harbor provision in a single word, it's going to be absurd. How does a company cure a breach that's happened already? It's like unscrambling eggs. CCPA doesn't explain how to cure a breach, and it's probably not going to suffice to show remediation efforts designed to prevent future breaches. Any cure that potential CCPA plaintiff might accept probably means paying money, but the odds that enterprising plaintiffs' lawyers advising their clients, they're probably going to tell them not to accept money so they won't be picked off as a potential class rep.
So I think Jason's really made the point, which is although there is a putative safe harbor provision in the breach context, you can't find a lot of solace in that. You know, one of the big questions has been, what do we expect the scope of litigation to be involving the CCPA? Because on the one hand, is it limited just to the breach context? And I think we're going to get an answer to that relatively quickly, in the sense that of the several lawsuits that have already been filed, they're all in the breach context, and certainly we would expect breaches in particular to trigger this sort of claim. However, at least one of the lawsuits also has a claim for violations of the substantive provisions of the CCPA, in other words, the non-breach provisions under California 17200. Any of you is unlucky enough to be involved in litigation, probably are in California, are probably familiar already with section 17200. It rides sidecar in almost every sort of lawsuit, and to date has certainly been seen in data breach lawsuits. Now, on the one hand, the defense bar is going to argue that outside the breach context, there's no private right of action for a CCPA violation. However, 17200 allows a borrowing, quote unquote, from other statutes to form its claim. And really the question comes down to, as posed by the Ninth Circuit, is whether or not the legislative history indicates that there was an intent to affirmatively intended to preclude indirect enforcement, for instance, through 17200. The fact that the CCPA has a private right of action for breach but not other violations itself is not determinative. Again, the Ninth Circuit has previously spoken on that and said it does not matter whether the underlying statute also provides for a private cause of action. Section 17200 can form the basis of a private cause of action, even if the predicate statute does not. So what does the legislative history of the CCPA tell us? It is, in some respects, inconsistent. We look at the breadcrumbs, and on the one hand, there's commentary, including from the judiciary, that adoption as is might limit claims under 17200. We might put that in the column of saying, okay, you can't have a 17200 claim. On the other hand, there's certainly also indications that the statute's intended to be read as broadly as possible. So consistent with what we've already seen, which is plaintiffs bringing a 17200 claim under any of the three prongs, unfair, illegal, or fraudulent, we expect that 17200, until the courts say it can't be used, will be used as a secondary indirect attack under the CCPA in both the outside the breach context as well as just for substantive violations. I also think it's worth noting here that even without the CCPA, there are already statutes that are currently used in the breach context in California, including the notice statute, as well as an independent reasonable security statute that are typically seen in data breach lawsuits. Those ride along with negligence, breach of contract, express and implied, sometimes fraud claims. So again, it's not a question of will the CCPA be added as a claim? Yes, it will, but it's certainly not going to be standing alone. I'm going to pivot now and talk a little bit about defense strategies and mitigation. And I'm going to start with Spokio and Article 3 standing. As you are all familiar in the federal context in particular, Article 3 standing is a threshold requirement to show a case or controversy. And the standard for that's probably familiar to most of you. There has to be a proof of, quote, actual harm. It has to be fairly traceable to the alleged misconduct, and it has to be redressable by the lawsuit. Typically, Article 3 standing has been a battleground for data breach simply because of the ubiquitousness of data breaches. It's hard both for a plaintiff to quantify and identify an actual injury. So say, for instance, in the scenario where your credit card data is exposed in a breach. However, you're never charged because either your credit card company has made you whole or you cancel the card. Where then is the actual injury? We have litigated and won from a standing perspective on those sorts of claims because you can't show an actual injury. Focus on the second prong, fairly traceable. Likewise, even though you may say that the exposure of your data is an injury in and of itself, how can you link it to a particular breach given the number of breaches and the various sources in which your data can get out into the public? Again, although there's been a split in circuits, and the Ninth Circuit certainly falls on the lower bar threshold for Article 3 standing, it's been an argument in the past we've been able to make. That shifts slightly now in the context of the CCPA because the statutory damages requires no proof of actual harm. Also, and as I think Jason previewed, it may make class certification showing damages on an individual much less a class basis easier. So what are we supposed to do? I'm not saying we're giving up on Article 3 standing, and certainly if I were in circuit other than Ninth Circuit, I think I'd still argue it. CCPA is just another hurdle to it, but that doesn't mean we're without any techniques. One thing I'm definitely going to recommend to you all, if your business allows this and there's an opportunity, is an arbitration provision with the class action waiver. So, and I say those in the same sentence for a specific reason. Generally in California, class action waivers standing alone are not enforceable. They are, however, in the context of a binding arbitration agreement. Now, the plaintiffs will argue that Section 1798.192 of the CCPA expressly disqualifies companies from using class action waivers. But I will say that we have also litigated and won on arbitration provisions, notwithstanding statutes like this, where the class action waiver is coupled with an arbitration agreement. It comes down to a preemption argument, and notwithstanding the policy arguments that are built into the CCPA, there is a stronger argument in favor of arbitration. So although the battleground has not yet been resolved and it is teed up here, I would certainly recommend that you consider putting in an arbitration provision with the class action waiver, and then we'll see how the courts resolve it, but it's a protection that can be very powerful. Nothing takes the wins out of the sails of a plaintiff's putative class action more than being compelled to arbitration in an individual plaintiff matter. Considering your arbitration agreement, again, include a class action waiver. I will also throw the yellow caution flag that you will always see attacks back based on lack of mutual assent and unconscionability. Remember, unconscionability has both prongs of procedural and a substantive provision. And so be aware of that in how you draft your arbitration agreement. Make it prominent, make the letters large, cap, bold, be clear about what's being waived. Ideally, the consumer would have to actually assent affirmatively in order to acknowledge and agree to the class action waiver. You know, a lot of what we've talked about has been the dangers of the CCPA, and there's reason to be concerned, but that's really more like the Boy Scout model. Be prepared, you will be less concerned. And so just to recap some of the advice we've had for you today, encryption and redaction. Let's not even get into a battle of the reasonableness of your security. Let's take you out of the clutches of the CCPA by saying that the data is either encrypted or redacted. Consider having an arbitration provision that is prominent and made part of your terms of service, that limits rights, that builds in a class action waiver. The next thing I'll say is, in data breach cases, sadly, the defense is often killed by friendly fire. What do I mean by that? I mean that internal communications tend to be the plaintiff's best evidence of lack of reasonable security. And, you know, from a psychological standpoint, it's totally understandable. For your teams, your security teams in particular, are working in a high stress, high stakes environment. And there's a tendency to use gallows humor because, after all, you know, although people like to infer if there's a breach, there must be weak security or security that's not reasonable, the defenders have to be right 24/7, whereas the attacker has to get it right only once. So what you see in Slack chat, text, emails, things that for whatever reason security team don't always recall are discoverable, is a lot of this gallows humor reflecting on security vulnerabilities, frustrations, that sort of thing. Those things will come back to haunt you in a litigation, and they will be used as the plaintiff's best evidence of lack of reasonable security. So I'm very much going to encourage everybody on this call to think about that. I will tell you, nobody wants to see their text messages blown up and used as Exhibit 1 in a deposition. But I think this really counsels in favor of having learning lessons, particularly with your security team, but really anyone who could touch one of these issues that might be generating evidence in the form of email communications, about to be mindful of how they're communicating and not to think because they're texting or using Slack or some other off-channel form of communication that those communications won't see the light of day. They will. The other piece of advice is it's very important as soon as the moment of a breach, you're going to be evaluated both from a looking backwards perspective of what was your security posture leading up to the breach, as well as from the moment of breach forward, what did you do? How reasonably, how effectively, how quickly did you act to both expel the intruder, but also to protect the consumer? It's critical that you have an operative incident response plan and that you follow it. Even the best policies and procedures will be of no use to you if they stay in the drawer. So again, I'm going to very much recommend that you do a review of your incident response plan, that you do preparedness training, and that you really make sure that when later evaluated about what did you do against your own incident response plan, that your actions will be considered reasonable. Under the category of friendly fire, I'm also going to say that any robust security culture, of course, builds in some element of self-reflection and self-evaluation. And frequently and understandably, companies engage third parties to do vulnerability testing as they must, to do maturity assessments as they must, security assessments, and all of those things. Be mindful of what's communicated. Be mindful whether you're doing that under privilege or not, because again, all of those things will form the basis of an after-the-fact review of the reasonableness of your security. So I realize that this isn't all happy news that we've delivered today. However, hopefully you'll find in here some tools to prepare yourself for the coming CCPA litigation. Lisa, I'm going to turn it back to you.
Okay, thank you so much, Anne-Marie. We have some really good questions, so I'm gonna run through some of these, and some are for our litigation colleagues, my litigation colleagues, and some are general CCPA questions. So I'm going to go through some of these. So one question that we received is a service provider obligated to publish a privacy policy on its website while providing services for another business, or does this only relate to businesses? The answer to that question is it is up to the business to provide a privacy policy with respect to data the business collects. I'll note that most service providers are also businesses. So there's sort of a hybrid role between the service provider qua service provider, and the service provider as a business for its own data that it collects outside of the service provider realm. So probably there is a need for a privacy policy, but not with respect to the data it collects as a service provider. Assuming that, by the way, that you sign the service provider written agreement that's required with the mandated provisions for service providers. There's another question that I thought was really interesting that I'll read out. My company's web developers refuse to learn anything about this subject, insisting they're not lawyers. Is it reasonable for us to insist that our web developers be able to build a compliant website? Yes, it is so reasonable. This is hard. And this really has to be a joint exercise as between the lawyers and the business and the web developers and anybody else who needs to be involved in this exercise. This is very much a game that needs to be engaged in by everybody who has any interest in this. So yes, you should expect that your web developers and others will play a role in CCPA compliance.
Can I just jump in there, Lisa? I
Please.
agree, absolutely. This is a team sport. And one of the things we'll likely see, by the way, in litigation is if you're relying on a service provider for a certain piece of your compliance and they don't do it, they should expect to be sued by you. So the answer that they're not lawyers is completely unsatisfactory. And I would advise them to get some lawyers before they find themselves in legal trouble.
That may raise indemnification issues. So examining your contracts with third parties, just in that you have appropriate indemnification provisions in place.
Great. Here's a question that's a narrow one, but of interest probably to many of you. Do you think a company can offer notarization without paying the notary fee as one option for identity verification, as long as there are other free options for identity verification? The regs say that you shall not require that somebody use a paid method unless you're going to pay them back for it. So I suppose you could argue that you don't have to pay them if you're offering other options. But honestly, I don't know that I would take the risk here, because it seems like an easy target if you are not reimbursing for a notarization fee and you're requiring notarization even if you have other methods, then I would say probably not worth the risk. Gotten a couple of questions on the moratorium on HR data and B2B data. So, I wish I could, I had a crystal ball and were a better prognosticator than I am, but this is something that's really causing a ton of hand-wringing, because the moratorium on HR data and B2B data ends on January 1, 2021. And so right now, based on the current rules, everything that we have to do for traditional consumers, we're going to have to take all those same actions for HR data and B2B data. I worry about the current state of affairs, and that there won't be time to really massage and consider the HR and B2B issues carefully. It may be that leads to a further moratorium, or it may be, as privacy activists are arguing, that now is a more important time than ever to have privacy protections in place. So the moratorium should be lifted on January 1, and we should be required to comply with all of the rules vis-a-vis HR data and B2B data. So I don't have, unfortunately, the crystal ball. I wish I did. But the one thing that I will say is don't wait, because I think it is going to be very hard to comply with all of the rules, particularly with respect to HR data. The right to know with respect to HR data is especially daunting. So I would not wait to put together or to start putting together a program. And if we get some leeway, then that's good, and we're not going to argue. But we certainly can't be assured of that. We have another question from France. What's the influence of the GDPR on the CCPA? Well, Boy, it's huge. When I first read the CCPA, I took a red marker and I circled a whole bunch of phrases that were just lifted directly out of the GDPR. So very significant influence. And in fact, we have no interpretation yet of the CCPA. So what we have been doing at Hunton is we've been going to our EU colleagues to say, well, how do you manage this? How do you manage that? When the concepts are, virtually identical in the GDPR and the CCPA, but we don't have any precedent. So we don't really know how to manage some of these issues. We're looking to Europe for precedent. Having said that, I would call the two laws sisters, but not twins. There are some very different concepts in the CCPA, real, vagaries truly in the scheme of global data protection law, which, I think global data protection law really takes much more closely hews toward the GDPR. The CCPA is its own animal. So we really can't consider them to be the same type of law. We consider them to be in the same ballpark, but they are not the same. We do think we can take some lessons from the GDPR, and certainly I would imagine that the AG is going to be looking to the GDPR for some interpretation. I'm going to turn to Anne-Marie and Jason. Can you address the potential for disclosure-related lawsuits related to the transmission of unencrypted online transaction identifiers like order IDs, quote IDs? Questioner says, I'm thinking here specifically of standard transmissions through pixels linked to advertising ecosystem partners.
Okay, so Lisa, I'm first going to ask you whether that scenario described in your view would violate the substantive provisions, and then answer what I think that means in terms of litigation risk.
Yeah, so we have a very broad definition of personal information, extraordinarily broad in the law, with respect to the substantive privacy provisions, where there's no private right of action. Separately, we have a private right of action with respect to data security, where the data elements at issue form a much, much narrower set of data elements. So I think I'm going to reshape this question to say, can you address your thoughts about how the plaintiff's bar is going to think about bringing an action with respect to the substantive privacy provisions, even though there is no private right of action built in for those, for a violation of those provisions?
Okay, so here's the answer. If there is a breach, right, then there's a clear private right of action. If you're talking about a transmission that the plaintiffs are going to argue is itself a violation of the substantive provisions, but is not an unauthorized access, exfiltration, theft, and then I'm going to say, what does disclosure mean? That's somewhat of an open question and one that may be subject to interpretation. Then I think the answer is it still may be vulnerable to litigation through the mechanism we discussed a little earlier, which is even if the plaintiff doesn't have a private right of action claim as a true breach, I think it's possible that a plaintiff might try to fashion a negligence claim or certainly a 17-200 claim borrowing the substantive provisions of the CCPA. And then they're going to layer onto that, they'll use the CCPA provisions as an indicator of what the expectation is of the consumer, and to the extent that the company has somehow deviated or not met that standard, then a negligence or a 17-200 claim may be used to bring a private right of action indirectly. Now, what's the likely success of that? Again, I think it'll be tested relatively quickly because of the handful of lawsuits that have already been filed about the CCPA. At least one of them includes a 17-200 claim cobbled together from an alleged substantive violation of the CCPA. So in addition to these breach lawsuits, I expect companies should receive a flurry of requests of information about how companies use their information. And I do think it's likely that depending on the answers to those questions, that a plaintiff may try to fashion indirect attack through 17-200 in circumstances like the one posed in the question.
With respect to the statutory damages that we had talked about, again, if this is in a scenario where it's not an unauthorized access or disclosure, then I think we can put those statutory damages aside. I'd also note, as Lisa had noted, The definition is going to be a lot narrower under the CCPA private right of action, again, where the statutory damages are. And that's going to be things like social security numbers, driver's license numbers, account numbers, medical information. So from the defense perspective, I think we would have a good argument there under the CCPA private right of action.
All right, thank you so much. I'm going to wrap things up. I know we're bumping up against time, and it truly has been a real pleasure to do this. We love speaking to humans given the current circumstances. Thank you very, very much for joining. Please do visit our privacy blog at www.huntonprivacyblog.com, where we post the latest developments on these issues and other privacy and cyber issues globally. We're going to follow up with everyone to provide a recording of this webinar as well as materials from the program, and we look forward to having you at future events. Thank you again.
Thank you all.
Thank you, everyone.